Court does call the case of the people versus Philip Barnhard.
Action calls for the people in both matters.
Assistant Public Defender Ben Dunaway on behalf of Mr. Barnhard, who stands to my right. Would you state your name for the record, please?
Philip Barnhard. What are we doing?
Your Honor, Mr. Barnhard is prepared to waive his exams. I think there may be another issue that the APA wants to bring up, though.
Report and receipt of the bond violation report from Community Corrections.
I have a report dated September 10th, the progress report, yes.
Yes, Your Honor. And I understand that the defendant was released from jail on September the 2nd, went to Community Corrections to test on September the 3rd. And when he tested on September the 3rd, he tested positive for cocaine, THC, benzodiazepines, and Suboxone. I understand also that this was his first test, so there is an argument that he may not have been on bond at the time that these substances were consumed, therefore.
Wow. Right out of the gate, this case hits heavy. Philip Barnhard is standing here accused of multiple OWIs, and the first thing the court addresses is a failed drug test, cocaine, THC, benzodiazepines, and Suboxone all in his system. This wasn't months after release, it was literally his first test. And that immediately sets the tone. Is this man actually safe to be out on bond?
So there were 3 days in custody. So it's possible that certainly the THC could have been from before. The cocaine, I'm less certain of, with extremely heavy use, maybe 96 hours on cocaine, but no matter what, these are OWIs at least 4 and 5, and there's another pending OWI in Wayne County. I'm very concerned that he is not able to control his substance use and is a danger to the community.
Your Honor, I believe there's a window that would make this not a bond violation. I think if he would have used on August 30th or the 31st.
But if this is a 5 and this is showing up in his system at all, I would consider him a danger to the public and that his bond is inappropriately set. So I'll let you make your argument, but.
Can I have just a second, Your Honor?
Sure.
So, yeah, I just think there's possibilities that he's not used after being arrested. And those.
What?
Cocaine could stay in his system for up to a week if there's heavy use. So the failure.
Let's say, I don't know, a week, but let's say I agree with you regarding that. Then his bond, and this is what I'm saying to you, then his bond on these operating while intoxicated, since I have 2 in front of me and there's another one in Wayne County, then I think that his bond in these cases is inappropriately set. And what I mean by that is that I clearly have these 2 cases. There's the other one in Wayne County. He's got priors and he's still using.
What strikes me here is the defense trying to argue timelines, basically suggesting maybe he used before being released, so technically it's not a bond violation. But think about it, does it really matter if the drugs were in his body before or after? This isn't some first-time offender. This is a man with multiple OWI cases stacked up. And the judge clearly isn't buying the hair-splitting. He's looking at the bigger picture, public safety.
Sure. But here's, again, my problem, counsel. My problem is really the danger to the community. Because I have an incident that occurred in February of 23. This other one occurred in July of 2023 or 23. He's got a pending Wayne County one. He's got prior ones and he's still using. So I don't know that he should be out because at some point luck's going to run out. He's going to get behind the wheel and he's going to take somebody out.
This moment really got me. The judge says flat out. At some point luck's going to run out. He's going to get behind the wheel, and he's going to take somebody out. That's chilling, because it's true. With repeated OWI offenders, it's only a matter of time before tragedy strikes. And the scary part is, we've all seen these stories in the news where someone with multiple DUIs ends up killing an innocent person. The judge isn't just being tough, he's thinking about the family that hasn't yet lost someone.
So you're arguing to me that with all, this is legitimately 4 and 5, with another one pending in Wayne County, and he's still using? You're saying it doesn't show to me that he's a danger to the community?
I think if he was driving, I wouldn't absolutely not even argue that, no question. I think him failing those tests, and we don't have a pattern or anything like that. You know, we don't know if this is a one-time slip up. We don't know if he's used while he was on bond. I think the court could allow him to test today, and that would solve the problem.
May I respond?
Right.
I would wholeheartedly disagree that there's no pattern. I think that the defendant having 3 previous convictions for OWI in 2002, 2004, and 2016, a 2023 Wayne County case, a 2023 Washtenaw County case, and a 2024 Washtenaw County case is absolutely a pattern. Furthermore, Your Honor, in this matter, if I recall correctly, and I think I do, but I will make sure, I believe his BAC was incredibly high. And I'm going to double check that before I get that search into the court. But if I recall correctly, I think in both cases, his blood alcohol content was above a 0.3.
That's correct, Your Honor.
So we are not, if this isn't a pattern, I don't know what a pattern.
Here's where the prosecution really nails the case, a documented pattern going back decades, 2002, 2004, 2016, and multiple cases in 2023 and 2024. And not just drinking, but blood alcohol levels over 0.30, that's near blackout territory. At this point, it's impossible to argue this is a one-time mistake. This is a lifestyle of dangerous behavior, and the prosecutor makes that crystal clear.
You wish these set for?
I'm sorry?
What did you wish these set for? Preliminary examination?
No, he's going to waive.
He's waiving. All right. So at this point, what I will do is his bond is going to be changed. I'm going to set it at $25,000.
And here's the big turning point. The judge revokes the personal recognizance bond and replaces it with $25,000 cash or surety. That's a major shift. It shows the court saying, enough is enough, you can't just walk out the door after this history.
Yes, sir. You understand you will not have that hearing on either one of these matters, and this will proceed to circuit court for further resolution. Sir. People also waive their right.
We waive, Your Honor. I do believe he previously posted $25,000.
Oh, are on both of these?
I think that's what my notes reflect, is that that's what it was set at.
I mean, I thought they were PRs.
Sign the
It
form
might
to
have been
waive
PRs,
after
maybe
this.
$25,000 PRs, but I
There, I have on each of these that they're PR.
Oh, I apologize, Your Honor, my mistake. Thank you.
So people do waive.
We do.
Preliminary examination haven't been waived. Defendants bound over to circuit court on the single count in each case.
We will stand mute, waive the formal reading.
Defendant having waived formal reading, standing mute, court will enter not guilty plea pretrial. Custody pretrial date.
September 24th at 1:30 with Judge Conlon.
September 24th, 2025, 1:30 before Judge Conlon in each of these matters. Bond, as indicated, is set in each case. It will be changed from a personal recognizance to a $25,000 cash or surety.
The final wrap-up feels procedural, but the impact is huge. Philip Barnhard is no longer free to come and go. He's bound over to circuit court with a much stricter bond. And honestly, watching this play out, you realize, the system tried giving him chance after chance, but his own actions kept proving the risk.